Hi everyone, this is Dr. Victoria Namle, and here with me is Mr. Kazim, who's a PhD candidate from the University of Aberdeen. So in today's webinar, we're going to talk about the role of arbitral tribunals in resolving energy and natural resources disputes in Africa. This is part of the webinar series that we've been hosting, which is as a result of the book project entitled International Arbitration in the African Energy and Mineral Sector, edited by Dr. Victoria Nalule, myself, and Professor Damilola Olawoye. So the book project is a live book project, and we're expecting over 50 chapters discussing various issues with respect to dispute resolution and international arbitration in the African energy and mineral sector. So in today's webinar, Kazim is going to briefly take us through his book chapter. But before that, I would like him to introduce himself. Kazim, take time to introduce yourself, give us your brief biography, just sell yourself at this moment in time, and then there afterwards we can go ahead with the presentation. Thank you.
All right, thank you very much for the introduction. I am Ilyas Kazim. I am a partner at the law firm of Sholias LP in Lagos, Nigeria, and I am a PhD candidate and teaching assistant at the University of Aberdeen School of Law. I am originally from Nigeria, where I am qualified to practice law, and for the past years, I have been practicing law in the areas of litigation, arbitration, and commercial law. Recently, I'm focusing my research interest in international arbitration of energy and natural resources disputes. Thank you very much.
All right, thank you very much for the introduction and for telling us more about your expertise in the energy, but also dispute resolution sectors. So let us start with the discussion. Can you give us a brief background about your topic or book chapter with respect to the role of arbitral tribunals in resolving energy and natural resources disputes? What are the key highlights from your chapter, your book chapter?
Yes, thank you very much. What I have done was to prepare some slides. I will begin by thanking you, Dr. Victoria Nalule, and your firm for the work that you've been doing regarding this book project. I also want to thank Professor Damilola Olawoye, SAN, fellow Chartered Institute of Chartered Arbitrators. I also want to thank our attendees today. I believe that I have my mentors, colleagues, and well-wishers among the audience today. I thank you very much for your time for attending the webinar today. The background information on which my book chapter is premised, which for the purpose of our own topic, the role of arbitrators in resolving energy and natural resources disputes can be taken for granted without further inquiry, that one, disputes in this sector are often complex and they often require a lot of expertise. Again, Africa is a fertile ground for arbitration, looking at the number of African countries that are parties to the New York Convention on Enforcement of Foreign Arbitral Award, and number of countries that are also parties to the ICSID Convention on the side of investment arbitration. So another thing that we can take for granted for the purpose of my topic is that arbitration is the preferred mode of dispute resolution mechanism in this sector. And therefore, the sector has something to offer the arbitration community in helping development of certain practices, arbitration practices that can be useful to arbitration community. And it is also true that arbitration has something to offer the energy sector as well. So it's a sort of mutual relationship between arbitration and energy and natural resources sector in Africa. The question then is, what role is the arbitrators appointed to resolve disputes that are often complex, that often require expertise to play? And in my book chapter, I divided the role into two sets of roles, basically. And one aspect is the role of the tribunals towards the parties to the particular disputes that they are resolving. And this can be summarized as when you look at issues like procedural efficiency, when you look at the need to ensure that there's just determination of disputes submitted to the arbitral tribunals, and when you also consider legitimate expectations of the disputing parties before the tribunal, such as they having the expectations that the tribunal will determine all the issues submitted before such tribunals in a just manner. You would often find contentions. There are contentions as to one party challenging the decision of the tribunal or the other. But the point is that there are certain legitimate expectations which form the basis of the tribunal's conduct of proceedings in terms of looking at the parties to such proceedings. But the bigger picture is also that beyond the parties to the proceedings, it appears that decisions made by arbitrators also have broader implications on the sector itself, the energy and natural resources sector in Africa itself, in terms of legitimacy of the arbitration. When we say that arbitration has been accepted as a preferred mode of dispute resolution, it therefore means that for that to be sustained, arbitration has there's certain expectations are meant to be fulfilled by the tribunals in order to ensure that arbitration remains a preferred mechanism for dispute resolution in this sector. And of course, the development of the sector itself also affects the development of Africa, because in the book chapter, you will find that I also take for granted the assumption that Africa is a continent that requires a lot of development. And it is the case that the sector plays a key role in delivering developmental goals to the African continent. So I try to express my views on the role that tribunals are to play in this complex web of requirement for disputes in this sector. Also, so I structured the book chapter into 5 sections. So you would find all of the information regarding the introduction and background to the study in section 1. I looked at the substantive issues in section 2, procedural issues in section 3, and limitations to the powers of the tribunals resolving these disputes in section 4, while I present my conclusions in section 5. In terms of the language, I tried as much as possible, in as much as the issues in contention are quite complex, I tried as much as possible to express myself in a very simple language, just to make sure that I'm able to reach and engage with wide audience comprising of academics, practitioners, stakeholders, and generally students. So you would find that the readers will find that the book chapter is easy to engage with. And that's basically the summary of what the book chapter is about, in interrogating the role of arbitral tribunals in resolving energy and natural resources disputes in Africa.
All right. Wow, that was a very quick, brief background with respect to the role of the arbitral tribunals. So I'll try to take in questions from our participants. Is there anyone with a question? Maybe you can stop sharing the slides, and we'll see if we can take in questions from people.
All right, thank you.
Do we have any questions from the attendees? All right, if they don't have any questions, I would just ask like one question for myself. So with respect to the African continent and the various developments in dispute resolution, what do you think are the weaknesses when it comes to resolving energy disputes on the African continent? Because in most cases we see that most of the cases that concern African countries, they're decided in foreign arbitration centers, and sometimes not many Africans are represented in the arbitral tribunals. So what do you think are the challenges? What is making us lag behind, and what would your recommendations be?
Yes, I mean, from my experience, to be honest, I think that we have what it takes in terms of resources. If you look at the number of arbitrators and practitioners that we have, and I do not think that it is justified that disputes involving the energy sector or even other sectors in Africa are resolved abroad by foreigners, right? So I think that that's one of the biggest challenges we have in relation to arbitration in Africa. There should be more appointment of African arbitrators. There should be more engagement of practitioners who represent parties, especially with respect to dispute involving Africa, because what then happens where a dispute involves an African country and the practitioners that represent the parties are not from Africa, what then happens is that sometimes they have to engage African lawyers to provide, expertise and then some legal advice, even in respect to such proceedings, which then buttresses the point that in the first instance, the practitioners from those countries are meant to be actively engaged as representatives of the parties in these proceedings. Another thing that I see as a challenge is the perception about our judicial system, because regardless of the fact that arbitration is a separate mechanism for dispute resolution, arbitration still requires support or some sort of supervision from the judiciary. So take a look at, for instance, challenging arbitral awards. So if an award made by the arbitral tribunal is to be challenged, the court of the seats of the arbitration plays a key role, because that's the court where the parties are to apply to set aside the arbitral award. So if there are issues bordering on efficiency of the judiciary or the perception about the efficiency of the judiciary, because sometimes even some of the courts have done some reforms which can make them to be quite more efficient, to be able to make decisions very quickly and make quality decisions for that matter. But even if that is the case, that there's a reform in place and a court has been able to meet the standard requirements of efficiency, if the court has not been perceived to be so, because parties making the choice of seat of arbitration and the choice of who to appoint as arbitrator or counsel, they work with a lot of this perception. So if they perceive that there's no efficiency, even if there is, then they would have to choose a foreign seat of arbitration, but they would have to also choose a foreigners to resolve the dispute or provide them legal representation. So it's a mix of reality and perception when it comes to how efficient can the judiciary be in supporting arbitration in Africa. And I also really think that we should also consider intra-African arbitration system, in which if Nigeria is involved in a dispute, right, and the concern is that Nigeria being the seat of arbitration would not guarantee neutrality, then there's no reason why an African country other than Nigeria cannot be a seat of arbitration in that instance, instead of making the seat of arbitration to be London, to be Singapore, and so on and so forth. So intra-African country, because in the book chapter, you find a section where I try to analyze a case involving PNID and Nigeria, when the issue arose as to where the seat of arbitration being conducted in London as a venue should be, right? So that contention about Nigeria insisting that Nigeria is a seat of arbitration because the Nigerian law applied, Nigerian Arbitration Act applied, and PNID insisting that the English court was a seat of arbitration because London was designated as a venue. That contention could have been a bit more, efficient on the Nigerian side if they had pushed for an African country as a seat of arbitration, even at the stage of negotiating the contract, where the issue is about the neutrality that may be involved. So if Kenya is involved in a dispute, there's no reason why Nigeria should not be the seat of arbitration. If Egypt is involved in a dispute, there's no reason why you should, another African country like Ghana or any other country in Africa should not be considered. So I think that some of those issues constitute the challenges that we currently face in arbitration in Africa, especially in the energy and natural resources dispute sector.
All right, so we've got a question from Mercy. She's asking, can you comment on the effect of COVID-19 on energy disputes in Africa? How can it fall under principle of force majeure?
Oh, yeah. So I think when it comes to COVID and arbitration, two factors need to be considered. One is factors relating to the contractual disputes arising from inability or failure to perform contractual obligations as a result of COVID-19. And then the other aspect is how COVID-19 impacted arbitration, the conduct of arbitration proceedings. And I think that when it comes to this last one, arbitration community has done really well in terms of dealing with issues relating to disruption of proceedings as a result of COVID-19, because I think that immediately that the disruption started to happen, the arbitration community, and I'm using that just loosely because there are different arbitration institutions involved, which reacted very quickly to conduct virtual proceedings to ensure that parties were able to still somehow continue the process of dispute resolution, despite the fact that there were restrictions as to physical hearing and physical submission of the document, even though there are challenges also about access to internet for some people, and some argument about justice, that if parties want to have a plenary hearing, they would desire that they get maximum out of such a hearing. So, and how much more can you get when the proceedings are virtual? But apart from some of those arguments, in my assessment, I think that the arbitration community has done really well in ensuring that somehow efficiency was achieved and is still being achieved despite all of the challenges presented by COVID-19. But when it comes to the other aspect of contractual dispute arising from inability or failure to perform contractual obligations, again, that is also divided into two. There are disputes arising as a result of COVID-19 restrictions themselves, and there are disputes arising as a result of measures taken to address COVID-19. So take, for example, someone, say a party cannot attend to work on site because they could not, because of movement restrictions. That's one aspect. Then there are other aspects in which government has actually, taken certain measures to put in place, which it's not COVID-19 itself, but it's the measures taken by the government itself that has, led to a restriction that then lead to inability to perform contractual obligations. So when this arises, I think that a lot depends on the contract itself, the provisions of the contract that parties are to use in that kind of dispute, whether the contract provides for a force majeure clause and what's the extent and scope of the force majeure clause that has been provided by the contract itself. So a lot depends on the contract and the governing law. So tribunals tend to begin the analysis of how far to deal with the issue of force majeure by looking at the contractual provisions and then considering the applicable law to find a just determination between the two contending parties, with one party saying they couldn't perform and then the other party saying that they should have performed or they should be compensated for failure to perform. Thank you. All
right, thank you very much for the brilliant response. I don't think we have any more questions. Okay, I think we have one more. Okay, Mas is asking, as a follow-up question, let me just promote Mercy so that she can be. Mercy, do you want to talk to us? Do you want to ask your question directly? Let me promote you so that we can see your video to be more interactive. Okay. Marcia, I think you can speak now. Are you free to speak, or do you want me to just read your question?
Okay, good afternoon. Yeah, it's afternoon here in Nigeria. Please, I want to ask Mr. Kazim that as a follow-up question to what he said earlier about most arbitration seats not being situated in Africa, what can young arbitration practitioners who are enthusiastic about energy arbitration be doing to get exposed in the international commercial arbitration space? That's my question.
All right, thank you very much. That's a very good question. And I think that there are a number of things that young arbitrators can do. Part of it is what we are currently doing. So we are having a book project now. We are writing, so I just wrote a book chapter, which we are going to put out in the space there for anyone who is interested in to read. That sort of give you visibility, because it makes us to have more African voices. And I'm using voice literally, because this time around we are not speaking, we're writing. So by writing articles, by writing book chapters, by engaging in book projects, we're putting out a lot of African voices that the community can see, to be aware that we exist and we have certain things to offer. Right. So that's one aspect of it. So the other aspect is the regular things that we currently already do, like attending conferences, attending seminar, networking events, because whether we like it or not, the community still relies so much on networking, where if I know that there's someone who is able to offer what I need, I will reach out to them. And sometimes many of the appointments are made based on the network rather than advertisement. So it's not the case that arbitrators are needed and then advertisements are made, because part of the challenges we have in arbitration is that it's a private tribunal, especially for the commercial arbitration. It's the investment arbitration that has an element of public law and private law mixed together. So because it's a private tribunal, unlike when appointment of judges are made in courts, where certain transparency requirements are present, for appointment of arbitrators, there's so much reliance on networking. So if we are able to network more, we're able to show the community that we exist and we have something to offer. And I think that by doing so, we would be able to somehow challenge the status quo. And when we write and when we speak also, we should endeavor to mention this challenge that we are here. There are a lot of arbitration practitioners in Africa. Why is it that the community doesn't rely on them? Why is it that the community goes abroad to appoint foreigners to resolve disputes involving African parties and all of that? So I think that I believe very strongly that it's a challenge that we will surmount.
All right, thank you very much. I don't think we have any more questions, and this would be marking the end of our webinar. So before we end the webinar, I would like to ask you, Kazem, to give us the final remarks with respect to your book chapter on the role of arbitral tribunals. What should be the takeaway, just in summary, especially for African professionals, governments, and other relevant stakeholders?
So I want to say that when tribunals sit to resolve energy and natural resources disputes in Africa, they are actually helping to develop the arbitration practices that would help us to enhance the sector on the one hand, and on the other hand, that will help us to actually achieve the development of Africa in general. So I want to say that arbitrators are doing a lot and they should be recognized for doing so. And African arbitrators and practitioners in particular should be recognized more for the role that they play in achieving developmental goals in Africa. Thank you very much.
All right, thank you very much. And thank you very much for the brilliant presentation. And most importantly, thank you for accepting our invitation to contribute this book project, because it's a very big book project, and it's the first of its kind where we're having African experts really discussing or tackling issues with respect to international arbitration in the energy and mining sectors, because those are some of the sectors that we should really pay close attention to in Africa, so that we can develop, but also to see how exactly are we resolving the disputes. So thank you very much, Kazim, and thank you very much our participants, the attendees. Do not forget that you can share the link. We've been live on YouTube, so you can share the link with your colleagues who haven't been able to attend because they're busy. I know everyone now is back to work, so sometimes it's hard to attend webinars, but we've been live on YouTube. Share the link with your friends, and do not forget to subscribe to my YouTube channel. We're going to be hosting over 50 videos on international arbitration in the African energy and minerals sector. And I also would like to thank my co-editor, Professor Damilola, for the great work and also for accepting to take up this book project with me. Thank you very much, and I wish you a lovely evening. Bye-bye. Raymond.